Legalities. Nursing and the law. What are the rules? Statutes and regulations. Statutory law is the term that is used to define written laws. It's usually enacted by a legislative body. Statutory laws will vary from regulatory or administrative laws that are passed by executive agencies, and common law, or the law created by prior court decisions. A regulation is a legal norm intended to shape conduct that is a byproduct of imperfection. A regulation may be used to prescribe or proscribe conduct, to calibrate incentives, or to change preferences. An example of statutory regulation is the State Board of Nursing that passes rules and regulations. LPNs must understand their legal role as outlined in the Nurse Practice Act. I cannot say that enough. Not all healthcare professionals correctly understand the LPN's role. Unfortunately, this is why LPNs are not always utilized to their full potential. The Nurse Practice Act is the final authority on nursing practice, and LPNs have to be clear on their responsibilities to avoid situations that may be outside their scope of practice. Again, and I can't say it enough, each state's Nurse Practice Act is the final authority on what they can do. But each state may have additional content or may not have all of the content that is listed here. The primary responsibility of the State Board of Nursing is to ensure the safety of the public and the professional conduct of the nurse. The State Board of Nursing is responsible for the licensing and discipline of nurses, among other duties. Some states now post professional licensure-related information, such as disciplinary action, on the Internet for public access. Committees or councils that decide whether specific activities are within the scope of nursing practice in their state. Because an activity is legal in one state doesn't necessarily mean that it's going to be legal in another state. Discipline by the State Board of Nursing can include probation, suspension, or even revocation of the nurse's license. Information, again, may be public or private regarding actions that are taken against any nurse. The National Licensing Examination, again, is the NCLEX PN. A graduate is eligible to apply on completion of a state-approved nursing education program. On successful completion of the examination, the graduate will receive a nursing license. Interstate endorsements. It makes it possible to work in another state without repeating the NCLEX PN examination after you meet that state's individual criteria for licensure by endorsement. And multi-state licensure will allow a nurse to have one license in his or her state of residency and practice in other states, depending on each state's Nurse Practice Act and legislation. Excuse me. Kansas does not subscribe to multi-state licensure at this time. RNs and LPNs can lose their jobs and licenses if the care provided by the unlicensed assistive personnel, the UAPs, does not meet the standards of safety and effectiveness. In other words, the RN and LPN are ultimately responsible for the care that is provided to the patients. The phrase, "you are being held to the nursing standard of care," has important legal implications. We base the standard of care on what an ordinary, prudent nurse with similar education and nursing experience would do in a similar situation or circumstance. One way to think of common law is that it's the judge's interpretation of the statutory law. The judge's rulings help define the laws that are on the books, which are statutory law. Statutory law is often rather vague and needs some interpretation as to the intended meaning. Criminal and civil actions are two different systems. Civil actions can be filed even after a criminal action is unsuccessful on the same issue. A misdemeanor is going to be the least serious charge. The penalty will be a fine and no more than maybe 1 year in prison. It can be one or both. A felony is going to be a serious offense where the penalty results in more than a year's prison sentence, all the way up to death. Guilt has to be proved beyond a reasonable doubt. Assault is an unjustified attempt or threat to touch someone. Battery means to cause physical harm to someone. The assault is the threat, the battery is the actual contact. Patients retain the right to refuse any treatment verbally and may leave the institution when they choose, unless they are there for court-ordered treatment. Now, if they leave prior to receiving a treatment, they're leaving against medical advice, two things need to happen. They need to completely and fully understand the implications of refusing the treatment prior to leaving the facility. That's first and foremost. And secondly, to help eliminate any now I can't think of the word, responsibility of the facility, they are required to sign an AMA form or against medical advice form. So they're doing something that they have been recommended not to do. Treating a patient without consent is going to be battery, even if that treatment is medically beneficial. False imprisonment means keeping someone detained against his or her will, and this includes physical and/or chemical restraints. Defamation is damage to someone's reputation through false communication or communication without their permission. Libel is defamation through written communication or pictures. So in other words, it's going to be on paper. Slander is defamation by verbalizing untrue or private information or gossip to a third party. So libel is written, slander is said. The patient has the right to expect you to speak the truth. Additional unnecessary conversation with coworkers and those outside the agency can result in a charge of defamation. The same is true for taking unwanted photographs or showing a patient's injury, cancerous growth, gunshot wound, etc. to anyone else, students included, without patient permission. Physical and emotional abuse. You have a legal responsibility to report your suspicions or observations of abuse by following your facility's abuse policy. You are a mandated reporter, whether you're a student or a licensed nurse. If you do not report, you can be held liable in a court of law. It's important to be empathetic as opposed to being sympathetic so that your observations or reporting will be as objective as possible. You need to offer concrete, specific observations, quote statements that are made, and avoid offering a personal interpretation. And, emotional abuse is often difficult to identify but physical abuse is easier to identify, although the victim may find creative ways to hide the injuries for a period of time. Unintentional torts can be just as devastating to the party who is charged, even though intent was not present. The person did not maintain the nursing standard of care and did not do what a prudent nurse with comparable education and skills would do in a similar situation. Examples of unintentional torts will include negligence, which is conduct that falls below the standards established by the law for the protection of others against the unreasonable risk of harm. It is your conduct, not your intent, which is the issue. This is going to be the most common area that nurses are sued for. Negligence, there's also malpractice, there's also negligence by a professional. Common sources of malpractice will include medication and treatment errors, a lack of observation and timely reporting on the client, defective technologies or equipment, infections that are caused or worsened by poor nursing care, poor communication of information including change of condition, a failure to intervene to protect the patient from poor medical care. The thing we need to remember about malpractice or negligence is that all charges could be avoided by good nursing practice. Nurses assume liability for their own acts, irregardless of who ordered it or who told them to do something. Although the employing agency may assume responsibility for the nurse during a lawsuit, the agency can then turn around and sue the nurse. You can also be held responsible for the neighborhood advice that you give. For example, telling a neighbor how to care for his or her sick child. In order to establish duty, a relationship in which duty was owed has to be established. Duty includes a professional relationship between a nurse and a patient. If there are no damages from breach of duty, then there won't be a case. To establish proximate cause, the plaintiff must demonstrate a link between the act and the damage that was incurred. The nurse's attorney is going to help prepare the nurse prior to giving a deposition or testimony. The attorney cannot tell the nurse what to say, but can describe what questions to expect. It is acceptable for the nurse to admit that he or she doesn't remember or doesn't understand the question. It's very inadvisable to give more information than is asked for in a response to a question. You must always be truthful. It does help if you remember to pause prior to answering a question. If your attorney recommends that you do not answer a question, then do not answer the question. Consider consulting an expert regarding the need for a personal liability insurance. Ask to examine your facility's liability insurance regarding coverage for nurses. Hospital insurance policies often cover their employees only if the employee follows hospital policy during an incident. The American Nurses Association definition of patient abandonment is unilateral severance of the established nurse-patient relationship without giving reasonable notice to the appropriate person so that arrangements can be made for the continuation of nursing care by others. Some examples. The nurse has to first accept a patient assignment, and that will establish the patient-nurse relationship. The nurse must have severed the nurse-patient relationship without giving reasonable notice to the appropriate person so that arrangements could have been made for the continuation of care. The patient must be in need of immediate professional care, or circumstances must exist which would seriously impair the delivery of professional care to the patients or clients. So you can't accept responsibility for a patient and then on hearing report decide that you really don't want to take care of that patient. Different measures of accountability include the Nurse Practice Act of the state, the NAPNE Standards of Practice, the NFLPN Nursing Standards, and the NFLPN Code for Practical Vocational Nursing. Student nurses are held accountable for the nursing care that they give. They are held to the standards of the licensed practical nurse. Even though they don't have that license, they're held to that standard. It emphasizes the necessity to prepare for providing care for the assigned patients in the clinical area. The instructor is responsible to make patient assignments based on the student's knowledge base and their ability to give safe nursing care. In other words, the nurse cannot assign a student to care for someone that they are not qualified to care for, and if by caring for them they would provide unsafe care. The instructor is also expected to provide reasonable supervision for the care given by a student, or have a designee provide that supervision. In other words, another LPN or an RN. If you discover during your inquiry that your work will cover more than you have learned or tasks beyond the scope of practice, you have to say so. Getting a job just to get a job may result in your being fired or losing your license.